Smithtown Planning Board is now in session. Would you?
Of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We thank you. Please.
Good evening, Mr. Chairman and members of the board. The first item on the agenda, the Planning Department recommends the following items for adjournment as we have insufficient information to act upon them. Part 1, Item 2, number 2011-04, Indian Head Family. Item 3, 2010-06, KVC Holdings. Item 4, 2007-01, Gyrodyne Company of America. Item 5, number 2007-04, Society of St. Johnlin. Item 6, number 2009-05, FB4 Realty. Part 2, Item 7, number 1053A, Berg Estates. Item 8, number 911A, Glen Hill Northern. Part 3, Item 9, number TC11-01, T-Mobile Northeast. Part 4, Item 11, the 280A application of Olivia Estates. Mr. Chairman, these are the items the Planning Department recommends for adjournment.
Is there anybody here to be heard on those items to be adjourned? Hearing none, a motion.
Mr. Chairman, I'd like to make a motion to adjourn the items read.
Second.
All those in favor?
Aye.
Opposed? So ordered.
Mr. Chairman, before we begin the first case, I just want the board to be aware that on the agenda under Part 1, Items 4 and 5, 2007-01 and 2007-04, have been on the agenda for quite some time. Both of these applications are currently going through a secret review process, and it will be some time before we have a decision. Planning would like to remove them from the agenda until such time as they do have a secret and their environmental impact statement ready, and then we can bring them back onto the agenda for the board to hear them.
What did you say?
The board has to move to take them off the agenda. They were accidentally.
Oh, they weren't able to be here?
No. We're asking them to two items on the agenda to be removed that are going through an environmental impact statement.
You don't want to carry them until all that's done, which could take quite some time.
That's correct.
So I'll make a motion.
Yes.
I move that items number 4 and 5, which would be Gyrodyne Company and Society of St. Johnlin, be removed from the agenda pending the conclusion of the environmental impact statements, after which time they can be returned to the agenda.
Second.
All those in favor?
Aye.
Opposed? So ordered.
Mr. Chairman, we'll move on to Part 1 of the agenda. Item 1, number 2011-01, All Seasons Motor Lodge. The Planning Board will conduct a public hearing this evening, May 18th, 2011, to consider the above-referenced petition for a change of zone from R10, residential 10,000 square feet, to WSI, wholesale and service industry, in order to maintain an existing motel use, 4 one-story buildings containing 35 units. The site is approximately 6.75 acres, mostly rectangular, developed with 4 one-story buildings currently in use as a motel. The petitioner requests a change of zone from R10 to WSI in order to maintain the existing motel use. In addition to attempting to legalize an existing use, this is a request to amend the comprehensive plan. This is a combined petition for a change of zone for the southern section of the site and for a town board special exception for modification of an existing special exception use, petition number 1984-11. However, since the planning board is responsible only for hearing and making a recommendation on the change of zone portion of the petition, this memorandum addresses only the change of zone issues. This area was originally zoned for business uses adjacent to the roadway and residential uses set back about 200 feet from the roadway. By the 1960s, the site was split zoned for WSI uses to a depth of 200 feet along New York State Route 25 and for R10 uses for the balance of the site. The properties to the east and west had a similar history up through the 1990s. To the east, the properties remain split zone between WSI and R10 and are vacant. To the west, rezoning approvals in 2000 and 2006 resulted in the Tudor-Time property being zoned entirely OB, office building, petition number 1999-14, and the Alcamo property being zoned entirely WSI, petition number 2002-03. properties to the north across New York State Route 25 also have a history of being split zone between WSI and residential. The site is developed as a motel. To the east is vacant property, and to the west are a daycare center and a swimming pool sales business, as discussed above. To the south are single-family homes in R10 zoning. Across New York State Route 25 are a vacant lot, a vacant building, a swimming pool sales business, a car repair garage, and a filling station car wash, all in WSI zoning to a depth of 300 feet from the roadway. The motel has been in place since 1955. However, the development appears not to have been in compliance with a site plan since at least 1984, when application was made for a modification of a special exception use for an extension of the use. The site plan associated with that petition showed all the motel uses in the WSI portion of the site. What was actually existing or built or improved subsequently is different. There is one building with 15 rooms in the WSI portion of the property and two buildings connected by an exterior breezeway with 20 rooms and an office, as well as a single-family home structure with a garage in the R10 zone section. The petitioner is attempting to bring the use into compliance with zoning and for it to be possible to obtain site plan approval as well. Certain portions of the buildings do not have a certificate of occupancy. The main issues for this petition are the current and potential effects on the adjacent residential neighbors to the south, whether it is possible to bring the site into compliance, the appropriate design of the site for safety, access, and aesthetics, and the potential for a change in zoning to set a precedent for similarly situated properties. The board will want to consider how the current operation of the motel affects the adjacent neighbors, and whether a continuation of the motel use would require additional fencing or buffers, or changes concerning parking or traffic circulation on the site in order to eliminate or prevent negative impacts on those neighbors. The board will want to ensure, since changes to the site and the buildings have been made over time without permits or inspections, that all buildings on the site meet current building codes. They will want to review whether any structures or uses or proposed should not be permitted. In particular, the petitioner is requesting that the non-conforming single-family use be permitted to continue. The board will want to review the driveway on New York State Route 25 to determine whether the access is safe, especially if there is potential for an increase in activity at the site. Finally, they will want to review whether the landscaping or the appearance of the building exteriors are in need of improvement. Finally, the board will want to consider whether approval would set a precedent for similar change of zone requests in the area. There are 4 properties immediately adjacent to the east that are also split zone between WSI and R10, and that are immediately adjacent to developed residential property. Further east, there are about 15 properties that are split zone between WSI and R21, adjacent to developed residential properties, though many of these split zone parcels have only very small areas of residential zoning. On the north side of Route 25, there are about 10 split zone properties in this area. Given that there are so many properties that could request similar changes and cite this petition as a precedent to support such a request, the board will want to consider what types of buffers or other mitigation measures should be required as a general rule when such split zone properties are rezoned to permit non-residential uses to protect adjacent residences from the effects of commercial activity. The following response has been received from the Suffolk County Planning Commission. Pursuant to the requirements of sections A14-14 through 23 of the Suffolk County Administrative Code, the above referenced application, which has been submitted to the Suffolk County Planning Commission, is considered to be a matter for local determination as there is no apparent significant countywide or intercommunity impacts. A decision of local determination should not be construed as either an approval or disapproval. The Planning Department recommends this petition be the subject of an on-site inspection by the board. Mr. Chairman, this is the Planning Department's recommendation for the zone change petition number 2011-01, All Seasons Motor Lodge.
Thank you. Is there anyone here representing the applicant?
Good evening, Mr. Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. I've submitted the affidavit of posting and mailing to Blaise Donadio. As you can see from the radius map, I guess you have that before you. And as Blaze indicated, this has been a motel for many, many years and located on that property since the late 50s, early 60s. As also was indicated by the planning department, to the time, that application was done by my office some time ago, and it was zoned office building all the way to the rear of the property. It had been split zoned, as well as the Philip R. Calisi, that's Alcamo Pools. That was also rezoned to go all the way to the rear property line. It was split zone with residential in the rear. The client retained our office, obviously, to not only fix this problem, which certainly is an impediment to their continuing to do business, although they've done business this way for probably the last 30 years, with those buildings in place. In addition to us making an application for a change of zone, there are applications before the building department for certain and various permits, as well as the necessary special exception, which doesn't come before your board. So it would make sense to recommend approval of this extension of the WSI zone. It's been in place for many, many years, and in addition to the motel branch of the building extending into residential, there is also a single-family home on the property, which I believe is rented or used by the management. So it's not a situation that hasn't existed for many, many years. It should have been corrected a long time ago. We're trying to correct it now. So we ask the board for its favorable recommendation. And if you have any questions, I'd be happy to try and answer them.
Thank you. Is there anybody in the audience that wishes to speak on this? Would you come to the microphone and give your name and address, please?
My name is Charles Matson. I reside at 41 Astor Court, Cormac, New York. I live right behind the motel itself. I'm here with a few other persons from the same Astor Court area that borders on the motel. Over the years, we've had minor problems, and through Smithtown enforcement and different other organizations, we have gotten help in reference to different problems there. What everybody that I know of in Astor Court doesn't know what they plan to do. Do they plan to extend the buildings? They have to fix them up. They're in very poor condition right now, as they stated on the papers. A lot of work has to be done. But are they going to extend it towards the business, towards the southern line, towards our houses? Or are they going to go north, south, east, or west if they do more building?
Okay, we'll ask the council there if he has a response to that. Council?
There are certainly no plans to extend the motel units to the south, which would be near the residential properties. Obviously, they have a lot of work to do in fixing up the properties. There is a tremendous amount of work to just bring them up to par, and that's part of our application, to the building department, because there are building department violations and corrections that need to be done, which we intend to do. There's no intent to expand the motel.
Mr. Chabarko, just for the record, you also filed a special exception application, which means that, for the board's knowledge, this is actually a hotel motel is required to receive a permit from the town. The plans that are on file are only the plans that can be approved. And they, from my understanding, it's the existing structure that you submitted for. Was that correct?
I'm sorry, I didn't hear the last part of it.
The plans that you submitted were for the existing structure, for the special exception.
Yes, that's correct.
Okay, what we're saying is that only that could be built with the special exception. If there's any change or alteration of those plans, there has to be a new hearing before the town board, and new plans have to be submitted for public comment and review. So what you see is what we're going to approve, and that's it.
So in
That's
answer-
correct.
In answer to the gentleman's question, they can't go further south towards the houses at this point?
At this point, what you see on the aerial photograph is what the plans show. If they decide to make an alteration of those plans, which they're entitled to do, then they have to submit a new special exception application, and a new hearing has to be held. They haven't held the hearing yet before the town board yet.
Is there any intention to expand the existing structures in any way, or just is it your intention to fix them up, as you say?
The intention is to fix them up, as evidenced by, as Frank said, by the application for the special exception.
And what precipitated the application? I see the motel's been there since 1955. Did something come about that led you to come now in and try to get the special exception?
My assumption is that the building department found violations, old violations, and probably inspected, and that's why we're here.
Do you know that? Have there been violations issued?
I'm reasonably sure that violations have been issued, and we're in the process of applying for permits. And like I said, there's a lot of fixing to do in this motel. The gentleman that spoke is absolutely correct, and that's what we intend to do.
What about that buffer on the southern portion of the lot? Planning mentioned that one of the considerations that might be one of the considerations we want to take into account. Would you be amenable to increasing that buffer, improving it, et cetera, in the event as a condition?
Well, I'm not sure that we'd have to go to site plan again, but my client certainly would be amenable to a reasonable buffer in the rear. I'm not so sure that there isn't a lot of planting that's necessary in the back, too. It's been a long time since any fixing has been done there.
And what about the concerns for precedent expressed by planning up the road, that there's many similar situated properties, that if we grant this, now we have to go and grant a bunch of others?
Well, I guess I could say that in the reverse. You recommended approval, not you personally, but this board recommended approval on Arcolese Alcamo Pools to extend WSI all the way to the rear boundary line, and that traversed a residential district, as well as when we did Tudor Time, that was a split zone, and that was recommended by this board. And I
Was
think
it granted?
Tudor Time is the
Yes.
property right next door, right?
Yes, and that was not that was office building, an office building grant as opposed to a WSI grant, but it did extend it all the way to the rear boundary line. So the precedent is there. Sometimes it's a good precedent to take care of these split zone properties, because there really isn't anything you could do in the back if it's residential, legally do anyway. So we think it's a good precedent.
Pools, as well as for the Tudor Time, there were extensive buffers that were granted. In our correspondence, the next packet to the board, I'll CC a copy of what we put on those other properties, so the board could get a preview of what our recommendations might be.
Well, we're going to do an on-site on this.
That's correct.
So that, and at some point, you're going to have a recommendation from
Yes.
your department to us, and that recommendation will consider all the issues of buffering, and you'll make a recommendation to us that if this is approved, what type of buffering, if any, we should require them to put in there.
Yes.
It'll all be covered in your memo.
It will be this, this is not a secret. It'll be the same buffers that we required, which were extensive for both the Tudor Time as well as Alcamo Pools, which is just getting started with their buffer. But Tudor Time has established its buffer.
Can you maybe describe for the folks what kind of buffer you'd have in mind?
Well, it's going to be a heavily planted buffer. It's not going to be a lawn. It's going to be vertical plantings, trees, to act both as a visual buffer and to attenuate some noise.
Okay.
Tudor time is a good example of how we finished it off.
Didn't you just get done telling us that WSI was no good last week?
Yeah, I did. This
Is
the
there anybody
case.
else who would like to be heard on this? Would you come up and give your name and address, please?
Hi, my name is Anthony DeSalvo. I live at 39 Astor Court. My property is directly, my backyard butts right up to their property. And the main issues that, you know, as we see here as the neighbors of the property is they keep like the dumpsters right behind the property line. We had rodent problems. We spent money to clean that up. And I guess they leave them open, and that's how that starts. And also there's a lot of noise from them throwing and slamming stuff in there. The trucks run there for hours and hours. Sometimes the diesel rigs that stay overnight. If we have our windows open, you hear them idling and running. That's a problem. Like my neighbor Charlie said, we have called and they come down and take care of it, but after a little time goes, they just do it again and again. And there's a lot of yelling, rude, obnoxious yelling and screaming at all times of the day, at night, and early morning there. That's really not want to be heard if you're a family person in your yard. Those are some of the things I see. As far as Tudor time goes, that's a good thing. They're not noisy. They're quiet. The kids are there. Al Camo is down low. His business is over at 5. That's about it.
We're going to do an on-site, you know, on this before it even progresses there any further. And then we'll give some recommendations there to the council. And I'm sure there, the planning board there themselves there will have a review of the plans that are going to be done.
The problem with the dumpster being on residential property right now as we speak, that's a problem.
Yeah.
I've been there since 1987, and it's gotten worse as time going on, especially recently.
Okay, thank you. Is there anyone else who would like to speak on this?
Mr. Chairman?
Were you happy with?
I'd like to thank the board.
You're quite welcome.
Mr. Chairman, when we do our on-site, is it possible to also get the view of the property off of Astor Court? Would any of the homeowners along Astor who have made an issue of the dumpsters and such, how far is your property from the motel? In what side of view?
Come back up
Come
again,
back up, please.
sir.
And would it be possible when we do the on-site?
Let me explain the situation. When we look in our property line, it's about 15 feet of dead space, my fence and then a hotel fence. There's a lot of shrubs and trees there. When it's grown in the summer like now, we can't see through the property. I could see glimpses of the building. The dumpster is maybe from here to that desk, from here to that pole, from that fence of their yard. So I'd say from their fence about 30, 40 feet.
What's your address again?
39 Astor Court.
Do you mind
Okay,
if we come out to your
we're going to
property?
review all
No,
of
you can
the,
come to my property, yes. There's,
we-
my yard's not locked down.
Okay.
You
we're
can
going to
go right-
review from the
Dogs or
front
anything?
and the rear when we
We're
review
in the
this
rear.
on
You're
an
gonna have to
on-site.
go in the rear, and I have a garage back there, and you can see. You can look over the fence. You really can't see it, but the house is right there. But the most problem is like, you know, with the dumpster. It's a
That would be
problem.
helpful, thank you.
Thank you. Motion there for, oh, this gentleman here? Your name and address, please.
My name's Craig Krasanik, 47 Astor Court, 2 houses down from the other gentleman that was just speaking. I'm a little bit further away from the property line, but I agree with what they said about the noise of the trucks that are idling overnight. I've called several times. I like to sleep with my windows open and you hear them. You hear the the garbage trucks coming at ungodly hours in the morning, which is not so nice. There are a lot of people, and it must be, I don't know what kind of hotel it is, but there's a lot of noise in the middle of the night that people shouldn't be hearing. There's a lot of screaming, there's a lot of activity, let alone the shape of the condition of the facility itself. It needs a lot of work before they need to start rebuilding stuff to encroach on our property lines to devalue our houses. Thank you.
Thank you. Anybody else? A motion there for an on-site, please.
In the matter of All Seasons Motor Lodge, zone change petition number 2011-01. I move that we adjourn the matter pending an on-site inspection of the site by the board.
Second.
All those in favor?
Aye.
Opposed? So ordered. We thank you.
Mr. Chairman, the next item on the agenda, under Part 2, number 922 Sesame Estates. There are maps in front of the board members. The first map is a copy of the filed map for the original subdivision, and the map below it is the proposed map for Section 2. The applicant is requesting to amend the original conditions of approval in order to increase the yield for this subdivision from 9 lots to 10 lots. The Planning Board conditionally approved the final map of Sesame Estates number 922, Sections 1 and 2, on June 18, 1997. This application was approved for a 9-lot subdivision by extending an existing cul-de-sac known as Sesame Street, along with frontage on existing town roads known as Sabre Drive and Sabre Lane. At that time, the board required the applicant to file a declaration of covenants and restrictions with the Suffolk County Clerk, restricting the development of Section 2 to not more than 3 single-family residential units. The applicant is requesting the board amend Condition R of the final approval to increase the yield of Section 2 from 3 lots to 4 lots and increase the yield of the subdivision from 9 lots to 10 lots. Condition R states, a declaration of covenants and restrictions acceptable to the town attorney and the planning department director shall be filed in the office of the Suffolk County Clerk on all of the acreage within future Section 2 of this subdivision, stating that future subdivision of this property is limited to no more than 3 single-family residential dwelling units and shall conform to the conditions of the preliminary approval granted by the Town of Smithtown Planning Board on January 15, 1997. The map of Sesame Estates number 922 is comprised from a single tax lot that is 5.3 acres. The property is the site of the Willis J. Smith House, circa 1850, which is one of only a few surviving 19th century farmhouses in the Kings Park area. The Smith House is listed in the Historic Sites Inventory of the Town of Smithtown as site number KP18. During the preliminary review of this subdivision, the yield for the entire parcel was determined to be 9 lots, based on lot area, the amount of environmentally sensitive land, any required public improvements, the zoning district of the property, and the Suffolk County Health Department wastewater requirements. Additionally, in determining the layout for the subdivision, consideration was given to preserving a suitable sized lot for the historic home near Sabre Drive by locating most of the lots on Sesame Street in Section 1. As noted previously, the final map of Sesame Estates was approved for a clustered subdivision of 6 lots in Section 1 and for 3 oversized lots in Section 2. The actual permitted density in Section 1 was 5 lots due to the amount of environmentally sensitive land. The Planning Board approved the clustered design of 6 lots to facilitate 2 objectives. The first was to grant the applicant the yield of 9 lots for the entire parcel. The second was to increase the size of the lots in Section 2 in order to preserve a suitable sized lot for the Smith House. An analysis of the yield map for Sesame Estates shows a 5.3 acre or 231,156 square foot parcel divided into 2 sections. Section 1 was a total of 3.15 acres or 137,327 square feet and contained 23,328 square feet of environmentally sensitive land, leaving 113,999 square feet of buildable property. Section 2 was 2.15 acres or 93,829 square feet. In determining the yield of a particular property, The applicant is required to meet all applicable Town of Smithtown zoning requirements and, in addition, meet the requirements of Article 6 of the Suffolk County Sanitary Code, which requires a minimum of 20,000 square feet for each lot created. The buildable lot area for both sections would be the total of 231,156 square feet, less the environmentally sensitive land of 23,328 square feet, leaving 207,828 square feet of buildable property. The estimated area needed for all required public improvements was 25,500 square feet, leaving 182,328 square feet of land to divide into building lots. After meeting the Suffolk County Health Department requirement of 20,000 square feet for each lot, the total number of buildable lots is 9. Therefore, since the subject property does not have the 200,000 square feet of land necessary for 10 lots, the Planning Department finds that the original yield of 9 lots is still valid. The Planning Department is prepared to recommend denial. However, given the complexities of this issue, the Board may wish to adjourn in order to assess the issues in this case. Mr. Chairman, this is the Planning Department's recommendation for the waiver request for Sesame Estates, Section 2, number 922.
Thank you. Anyone representing the applicant?
Mr. Chairman, members of the board, my name is Vincent Tremarco. I represent the applicant. The one thing I agree with Planning Department is there really should be an on-site inspection and a careful review of this application. With respect to the historic house, the way we propose it now on lot number 1, you can see in your map there, it's on 25,000, almost 500 square feet, so it's not exactly a small postage stamp lot. I think when this was originally done, perhaps more thought could have been done to the way this map was filed, so that we have the additional yield of 1 lot. Obviously, we do have to meet health department requirements no matter what, and that's something that would be our burden. Again, I think if you looked at the property and you see how we want to configure these 4 lots instead of 3 lots, you might come to the conclusion that this is even a better application than with the 3 lots. So again, we asked the board to look at it, to examine the map carefully, and take a ride out there and take a look at this site, and then maybe come to a conclusion that might be different than the Planning Department recommends. You can see that these lots, 2 of the lots, back up on Route 25A, and there's a 15-foot wide limited access planting easement, which is a good thing. There is no access to 25A. It all comes off of 2 cul-de-sacs, which again we think is much better than connecting Sabre Drive, which would then make it sort of a thoroughfare from Ravenwood Drive and other areas in that development. So again, we asked the board to take a look and then come back with a recommendation. We certainly appreciated the first time you approved the map. We're in a situation now where this is my client's last piece of property. He he's not employed anymore, and this would be it for him. So again, we ask for your favorable consideration. Look at it, and then we maybe can come back and talk about it again. Thank you.
Frank, do you have a different map than the one that we have here, showing the revisions that he wants to do?
Do we have?
Huh?
This is the second map.
Is there another one underneath? Okay. Let me get them both out here then. Wait till I just see if there's anybody in the audience. Is there anybody in the audience that wants to be heard on this application? No? All right, go ahead.
Mr. Rubius, in the memo, I just have a question. It says the entire parcel is 231,156 square feet, and there is 23,328 square feet of land which has been qualified or characterized as environmentally sensitive land, which looks like it's about a little over 10%. Why is it environmentally sensitive? What gave rise to that classification?
Steep slopes. It should be, well, we have it highlighted on a map. I don't know if it's on the map before you, but that was on the original map as well.
You have an elevation map also?
We do have a topo map. Do we have that?
And is the environmentally, do you know if the environmentally sensitive section is spread throughout, or is it confined to one area?
No, it's haphazard throughout the site. Blaze will show you the map. It's at different parts of the site. It's not consistent in one area.
To bring my guy.
Going to Sesame Street.
Where is the historic structure? That would be the house.
We can keep this.
Suppose there's no entrance from 70 then.
It's this, okay.
So what's being proposed is no entrance from Sesame, is that correct?
Yes,
Yes?
yes.
It's just gonna,
The
all
entrance
the
from-
entrances
there
to
are
the
two
property are gonna be done off of Sabre Drive one side and Sabre Lane the other side, is that correct?
Yes. And
You want to have like double cul-de-sac there?
yes, rather than, if you put the road right through, it certainly would make a thoroughfare situation and people cutting through to get to like Ravenswood, I think it is.
So there'll be no through street?
No through street, right.
Okay.
And I think the steep slopes, if you look at the topo, really affect the initial subdivision that was done in the back of this application.
Yeah, it looks like all the steep slopes are to the north.
Yeah, exactly.
And you're really talking about just the lots that are around Sabre then, right? That's what this application is for.
Yes.
Okay, we're gonna do an assessment and a review of this. And if there's no other questions then from members of the community here, we'll go for an adjournment for an assessment of this plan.
Chairman, with respect to number 922 Sesame Estates, I move that we adjourn the matter for an on-site inspection.
Second that.
All those in favor?
Aye.
Opposed? So ordered. Would you mind if I keep this map? Okay. I think that some of the members should get that, the elevation.
Yeah, I want to have
Yeah.
the topo map. I just want the topo map.
Yeah, I've got this one here, yeah.
Yeah.
Please.
Mr. Chairman, the next item on the agenda under Part 4, Item 10, number 1099, Glansman Plat. The applicant requests to extend the performance bond for a period of 2 years to expire on March 11th, 2012, in order to obtain more time to complete construction and all necessary improvements. The applicant received conditional final approval for this two-lot subdivision from the Planning Board on January 18th, 2006. A performance bond estimate in the amount of $11,324 was approved by the board and subsequently signed by the chairman. The applicant submitted the bond monies and all related materials to the town, and the town board accepted the performance bond on January 22nd, 2008. Planning board approval for this performance bond expired on March 11th, 2010. The engineering department contacted the applicant by letters dated February 16th and October 1st, 2010, informing them the bond would and had expired, and that they should contact the planning department to make the appropriate application to the board. The applicant submitted a performance bond extension application on March 11th, 2011 to the planning department, and the application was distributed to all departments concerned for review. The engineering, highway, and traffic safety departments have no objection to the performance bond extension request and have determined that the bond amount is sufficient to cover all remaining improvements. Planning has performed an on-site inspection of the subdivision and has determined that most of the public improvements have been completed. The applicant has submitted a waiver request for the installation of sidewalks within the subdivision. The Planning Department has no objection to the applicant's request and recommends approval. The Planning Department offers the following resolution for the board's consideration. Be it resolved that the Planning Board hereby approves a retroactive extension of the performance bond for the subdivision known as Glansman Plat, number 1099, for a 2-year period to expire on March 11th, 2012. Mr. Chairman, this is the Planning Department's recommendation for Glansman Plat, number 1099.
Is there anybody here representing the applicant?
I am. I'm Dina
Do
Olson.
you have an attorney there representing you? No?
No.
Okay.
This is my first time. Dina Olson? Yeah. And I also thought that I did everything on my performance bond. This is my first time ever doing this. So I don't know I just want to resolve it. And when I went down and I, paid my fees, and they said, okay, you have to ask for whatever you want waived to be waived. So I did that, filled out the application, paid the fee, and then they said, okay, you have to come tonight. And
Well, have you installed the sidewalks?
well, that's what I chose to waive. I put in an application to waive the sidewalks.
All right, so long as you know that the reason that we extend a performance bond is to make sure that before we do anything with the sidewalks, we know that the performance bond is in effect.
Okay.
Okay?
Okay. So now, since I paid the fee just to apply for the sidewalks to be waived, what does that mean? Is that money going to be held over, or?
No, you've got an extension. You've got an extension there. If we voted here, you've got an extension, but it's not going to clear up the issue there about the sidewalks until you come there to the planning board there with an application of what you want to do about sidewalks.
I did that.
Okay, before you can have a hearing on your sidewalk, what the chairman said is that your bond must be enforced. In other words, inactive.
Active, okay.
Okay, now
so
we
it's
can.
active right now.
It's inactive right now.
Inactive. If you approve it, then it's going
It
to be
becomes active, then we can schedule by law a public hearing. We cannot schedule a public
can't-
hearing
okay.
on an inactive. And Blaze has informed me that he's going to schedule it. That's the next item to be scheduled.
Oh, okay. That's
And
good.
and one more thing.
Yeah.
What you want to do is, if you do make the application to waive the sidewalks, make sure that you post the sign so that the neighbors see it.
Right.
I've been over there, and the sign there looks like it got blown down or something.
It got blown down because of the rain. It
Yeah,
just got blown
okay.
down. I put like
But just-
5
but,
nails in my tree.
It makes it there so that if there's any neighbor that wants to support or not support your sidewalks,
Right.
that they know that when the meeting's going to be.
Okay, so now
Okay.
I'll get another letter and it'll say, come pick up a new sign.
All right, when this is approved, then there you can go to Mr. DeRubis there, and he'll tell you when you can schedule there for the waiver of the sidewalks.
Okay.
Okay?
All right, thank you.
You're welcome. Anybody else on this application? Any questions from the board? A motion
Motion to approve a retroactive extension of the performance bond for the subdivision known as Glansman Plat, number 1099, for a one-year period to expire on March 11, 2012.
Second.
All those in favor?
Aye.
Opposed? So ordered. We thank you.
Mr. Chairman, the next item on the agenda, under Part 5, Item 12, number 1138 Ness Manor. The applicant is requesting a 6-month extension of the conditional final approval in order to obtain more time to comply with the requirements of filing the necessary paperwork required for the filing of the performance bond. The Planning Department has no objection to this request and recommends approval. The Planning Department offers the following resolution for the Board's consideration. Be it resolved that the Planning Board hereby grants an extension of time to the conditional final approval for the subdivision known as Nest Manor, number 1138, to September 17, 2011, for the complete submission to the Planning Department of the performance bond and all required documents. The extension is automatically extended to November 17, 2011, upon submission of the performance bond and all required documents by September 17, 2011. Mr. Chairman, this is the Planning Department's recommendation for Nest Manor, number 1138.
Is there anyone here representing the applicant?
I submitted the affidavits of posting to Blaze and Audio. Obviously, we concur with the recommendation of the Planning Department. I'm sorry?
Just identify yourself. Okay.
I'm on TV. What are you talking about?
We have a court reporter, please.
Thank you, Frank. Vincent J. Tremarco, 1038 West Jericho Turnpike, Smithtown, New York, for the applicant.
Anybody here on the application? No? Any questions by the board? A motion.
In the matter of Nest Manor, number 1138, I move that we adopt the resolution in accordance with the recommendation of the Planning Department.
Second. All those in favor?
Aye.
Aye.
Opposed? So ordered.
Mr. Chairman, the last item on the agenda under Part 6 is the adoption of the Planning Board meeting minutes for the February 16th and March 2nd, 2011 Planning Board meetings.
A motion to adopt the minutes.
Move that we adopt the minutes of the February 16th, 2011, and March 2nd, 2011 meetings.
Second.
All those in favor?
Aye.
Opposed? So ordered. There's one more item on the agenda tonight, and that is the request there of Mr. Tremarco and his clients there to discuss there an application that has been made to the board for consideration. This will be primarily an internal matter. We have had some discussion on it, and we have discovered in that discussion, we have discovered that there is a question about how the single and separate identification of a parcel prevails there in an application like this. So if you'll let me just explain, we have the council explain what the problem is. Then there, if you have any questions for me, I'll try to help you, but it's going to have to be something that's going to be handled there, probably there, in a legal frame. Counsel?
I believe the application of which you speak is one made by John Zolo as the attorney for the Smithtown Fire District.
That's correct.
The application, if I understand it correctly, is to ask this board pursuant to Section 323.7 of the Town Code to determine the number of density flow rights that emanate from this particular parcel. A perusal of the application and a view of the property, a description of the property, raised the question in Planning Department's mind as to whether, in fact, the parcel was, in fact, single and separate and met the requirements that this board could take under consideration. It's my understanding that the procedure to be followed should be an application to the building director for a determination of whether, in fact, planning's assessment is correct, that the property is substandard. If the building director finds the property qualifies, then it goes forward from there. If it finds it substandard, that the recourse of the applicant, the aggrieved applicant, which is the district, would be to make an application for a variance to the Board of Zoning and Appeals. Now, although Section 323 doesn't establishes procedure, historically, the determination as to whether a parcel would qualify has been within the purview of the Board of Zoning and Appeals. It's my understanding that the planning director has been consulted by the building director has been consulted by the planning director. He has indicated that his determination is the property is substandard, and is prepared to issue a letter to that effect, which would permit the applicant to move directly to seek a variance from the BZA. This board, until that determination is made, is not permitted to act. That's my determination.
Mr. Zola, would you give your name and address, please?
Yes, Mr. Chairman, John Bizzolo, 38 Southern Boulevard, Suite 3, Nesconset, New York. I didn't see this item on the agenda.
No, it's not on the agenda. It's on other matters.
Okay, and I just wanted to make certain that I was here, I received no notice, I received a correspondence from Mr. Tremarco, the attorney for the property owner, that it was on for tonight, so there's no posting or anything of that sort for this application. Just, I want to make sure that wasn't a prerequisite for speaking tonight. I understand what Mr. Schul, counsel for the board, has said. A couple of things, if I just might go through this with the...
I discussed that with the chairman and with the planning director. You are the attorney for the applicant, and you should have been consulted. This was more in the form of a courtesy to Mr. Tremarco and his client in response to the letter he sent to the chairman and each member of the board by May 5th. So I'll apologize. You should have been consulted at the same time.
Well, what I did, in order to represent the fire district, I prepared a presentation tonight, not knowing whether I was in fact going to be submitting my case tonight to the board for a letter of interpretation with respect to this parcel. So if Mr. Schul's opinion is what the planning board's going to rely on, then I guess I have nothing else to add at this time. I was not aware of that. Again, I prepared a presentation for this evening to go forward with this board, because I think, pursuant to Chapter 323, this board has the authority to make a determination with respect to the density flow rights of a certain parcel. Obviously, Mr. Schul disagrees with me that...
This board is certainly within our purview to determine the particular density.
Could you take the mic, please, so that we can hear you?
It's certainly within our purview
Oh, we heard
to
you.
make a determination as to the number of flow rights emanating from a particular parcel. It is not within our purview to make a determination of whether a parcel is substandard or not.
If I just, and Mr. Schul, just wanted to, if I could, one of the things that's troubling to me is that this is a case of first impression for the planning board, because no one else has made application for TDRs before this board, as I understand it. So the procedure that was set forth in Chapter 323, as we're going along, there's a learning curve for everybody. And I respect that, understand that learning curve for me as well as the planning department. But I just want this board to be aware that, and I had prepared packets for each board to show you how this property is situated. The property that we're talking about, that it's claimed has merged, fronts on Osgood Place. The other parcel that was put into a family trust in 1997 fronts on Harvard Avenue.
Mr. Zola, it's not my place, but I guess it's our dialogue. We're getting into, in fact, whether, in fact, the two pieces that are contiguous form one parcel which qualifies for TDR rights. That's not within our purview. Historically, by court decision, and in this town, the BZA has made those determinations. And with reference to my suggestion, although the letter of interpretation is one method that could be followed, Mr. Tremarco stressed the point to me that time was of the essence, because your contract has a 9-month window, and I confirm that by reviewing planning's file. You have a contract that either party may terminate after June 13th. So to expedite the process, Mr. Bongino's been conferred with. He's prepared to issue a letter tomorrow, so you can make your application to the ZBA within days.
Well, it would have been nice that I was informed about that, because I was not aware of that
This
at all.
occurred this afternoon.
Okay. But one of the things that I'd just like to point out, as I said, Chapter 323 is a brand-new ordinance. It's up, we can establish what this planning board's authority is, and without having, there is no case law with respect to this planning board's authority under Chapter 323, because it's never existed up until this time. This is the first time a case like this is being heard. So I was hoping that this board would take on itself to make a determination with respect to this parcel and these density flow rights that come from this property. But if that's the determination of council and that's what the board's going to follow, then I will respectfully pick up the letter tomorrow and proceed as Mr. Schuler suggested.
Do you, before we get to that, please, is it your position, Mr. Zolo, that you don't agree with council's opinion as to the lack of authority for this board to handle this application, that type of application, as opposed to going to the ZBA?
Well, my position is this board, if it so exercises the power, has the right to do that. That's my
So
position.
you don't agree with, I think what Mr. Schuler is saying is that in this town, this type of application has to go to the ZBA.
But the qualification of a parcel for our consideration under 323 is a condition precedent.
Right, in other words, there's
Before-
something that they have to decide first before we can decide what we have to decide.
Exactly.
So it's not really before us at this point.
That's correct.
And,
This is a new law, as we understand it.
Right.
And there's more sections to it than just 323.7. Or, yes, 323.7. And if you've reviewed the whole law, then that's where council is saying that there's something else that has to be done before the board can review it.
Understood. But we're here tonight, again, my point is, when I filed the application with the planning department, they were aware of this. I explained to them the property. I provided an affidavit of Mr. Machichi. I provided a letter of intent. You have everything that should be submitted with the application. And then after approximately a month, the application is submitted to find out now that it's the position of the town that the board has no authority to hear this is somewhat disheartening. And I respect Mr. Schuler's opinion to the board, and Mr. Tramarko wants to be heard, but we'll have to follow that. And then
I would just... The application you filed, I perused it this afternoon. In fact, the affidavit of Mr. Machichi refers to first parcel being 6,665 square feet. And then his third paragraph, he says that he became aware that you did a search on behalf of the applicant, and it makes reference to a second parcel. But quite honestly, from reading the affidavit, it's not quite certain how big the parcel is you're referring to.
well, the survey was submitted with the application.
The affidavit has to read and disclose the, in my opinion, the dimensions of the parcel in question. Doesn't do that.
And I would say, Mr. Zolo, if you are of a different opinion than Mr. Schul regarding the issue of whether or not this board can hear what you want it to hear before the Zoning Board of Appeals it determines a substandard issue, which I think is what you're saying, you can address that to him, and perhaps he'll consider it. But it seems like his position is pretty clear.
In fact, it's recommended that if we get the letter from building, which is going to confirm the initial impression of Mr. DeRubius, it comes tomorrow, they can make their application to the BZA for the variance, which they're entitled to at that point in time, and they have to apply to the Department of Health anyway. So that can be being processed at the same time and can be back before this board once ZBA acts, and it's a straightforward procedure. If they confirm the parcel is entitled to the variance, you qualify.
So basically, you're saying he's got to go to the ZBA first, get a determination of the substandard issue before we can even deal with
And
it.
you have, well, you have to, before we can act, you have the Department of Health approval as well.
May I be heard, Mr. Chairman?
Mr. Chairman? Yes.
Thank you. First of all, I wholeheartedly disagree with Mr. Schul. I don't think a reading of the ordinance, and it's a very new ordinance, as Mr. Zolo indicated, will indicate in any way, shape, or form that you don't, as the board, the planning board, have authority to rule on single and separate. Now, I'm going to hand up as Exhibit A, and maybe Mr. Roshman could pass them down so I don't waste a lot of your time. But this is the entire ordinance which was passed by the town board. Nowhere in that ordinance does it say or even indicate when it talks about single and separate that you have to go to another board. As a matter of fact, 323.7 says in private party transfers, the planning board is authorized after receiving approval from the Suffolk County Department of Health to permit a transfer of density rights. Now, there was a memo from Dave Flynn, which I'm going to hand up as Exhibit B. And that memo basically goes over, Flynn says it's his memo, but he also indicates that it's how can I put it, it's really Frank DeRubius's memo. And basically what he's saying is that he doesn't believe that the planning department has the expertise or the experience to rule on single and separate ownership. Well, I don't know. We've got 2 lawyers on the board, a real estate expert, a lady that's been working for a Supreme Court judge for many years before she retired, and of course the chairman who's been around even longer than I have. So you certainly have the expertise to rule on single and separate ownership. And the other part of this application is the fact that it's a two-part statute. One, you got to get planning board approval, and 2, you need the health department approval. The health department approval uses a different standard than the single and separate standard. The single and separate standard is basically what we know and what I've done probably a couple of hundred times at least before the Board of Zoning Appeals with respect to single and separate properties. The planning department, the health department standard is based upon when the property, how long the property has been in separate tax bills. And in this particular piece of property, it's been way before the standard of 1980 that the parcels would be viewed for density flow rights. So from the health department's point of view, and this is a big conflict in your ordinance that was, I assume, written by the planning department, the health department says, I don't care what name it's in, as long as the tax bills were separate before 1980. We've been separate probably since 1960 or before, and I don't think there's any question about that. I will submit in a couple of minutes the tax bills with respect to this property and also the tax map. Now, I think what John was trying to get to before with respect to the issue of single and separate and where it can be heard, yeah, sure, the Board of Zoning Appeals has heard it a million times, but that doesn't mean that this statute does not allow you, this ordinance, to determine what's in single and separate ownership. It absolutely does, because there's no qualification that if there's a question about single and separate ownership, that now we have to go to another board. It's ridiculous. You have a 6 or 7 page or 8 page ordinance, and not in anywhere in the 4 corners of those pages does it ever say you have to go to the Board of Zoning Appeals. I just think it's a stall tactic, and it absolutely makes no sense. We're supposed to be before this board. We're before this board, and all of a sudden now we have to go to the Board of Appeals. And even if we went tomorrow, as Mr. Schul says, and we got the denial, we wouldn't get before the Board of Appeals until the end of June, maybe. I don't know what the calendar is, but it's late. It's very late. But I'd like you to read those comments or the memo from Dave Flynn, because basically they're indicating that you're not qualified, in their opinion, to even decide single and separate. I'm sure that that's not the case, and I'm sure Mr. Shul, if he studied single and separate, he would understand it as well as me or anyone else. It's not brain surgery. It's a simple concept. So we're in this situation. We come before the board, and all of a sudden, out of the clear blue, now we got to go to another board. That's not what the statute says, and that's the first thing that I think this board has to take the time to rule on. If you feel you don't have the qualifications and the statute does not permit you to rule on single and separate and send it to another board, I think that's a dereliction of duty on your part, because your part is to decide this matter because you have been appointed by the town board by virtue of this ordinance to make all of these decisions, as hard as they may be or not as hard as they may be. Now, when I went to Frank DeRubius and I said to him a couple of weeks ago, what's going on with this application? He says, I'm not putting it on the calendar. Why? Because he said it wasn't in single and separate ownership. It's not his decision. It's this board's decision to make a decision with respect to single and separate ownership. Otherwise, this whole ordinance doesn't mean a damn thing. And we should be in the health department and not come here. Now, the single and separate, I'm going to just give you some cases about single and separate, and this is a classic type of case. This is a back-to-back split. A back-to-back split is different than adjacent properties. Machichi's dwelling house is here, and I'm going to give you a tax map, and the lot is on Osgood Place, as John indicated. So the question really is, in a back-to-back split, was the vacant parcel used in any way to enhance the dwelling house parcel? Did it make a difference if the vacant parcel was not, if it wasn't there, would it make a difference? And now that it's there, that's a bad way. Let me just strike that. Was the vacant parcel used in conjunction with the dwelling house parcel? It wasn't. This is a vacant parcel that's been owned by the Machichis, albeit it in the same name. And sometimes people, being laymen, they're told, as elder lawyers come in, they say, well, you got to put everything in trust. So they put everything in a trust. Now it's considered merged. But it's not merged because it's known as a back-to-back split. So what I'm giving you next as Exhibit C are the cases. There are cases decided by the Appellate Division, the Supreme Court, and the Court of Appeals saying that back-to-back splits are not considered to be not in single and separate ownership, because the theory is there was never any thought that the rear boundary line would be compromised and you would use the house parcel and the rear parcel, unless you actually did. In Mr. Machichi's case, he didn't. He's got his house parcel and he's got the parcel that fronts on Osgood. Now I'm going to give you some cases, and I guess I'd like all of you to read them, but I'm hopeful that Mr. Shul will read them. Now, I'm trying to go as fast as I can. The cases that you're going to see in Exhibit C, the first case is the matter of Burko versus Kern. Now, Kern is a pretty familiar name because Roy Kern was the chairman of the Board of Zoning Appeals probably for 30 years. And that case came about when the Board of Zoning Appeals said, no, this is a back-to-back split. We're going to grant them single and separate status. There was never any thought of using the vacant parcel in conjunction with the house parcel. The owners of the property, the Strains, came into this Board of Zoning Appeals in about 1992, and they said, hey, this is not right. We should be able to build on the other parcel. The Board of Zoning Appeals agreed with them. So Mr. Burko, I guess, decided, well, I'm going to sue them to show them that I'm right and there was a merger. As it happens, the Appellate Division held that there was no merger. because the lots were not used in conjunction with each other. Therefore, we are going to allow Mr. Strain to build his particular house on a lot which was touching the rear boundary line of another parcel owned by the Strains. Now, I'm just so you have it, I'm going to give you the ordinance, the single and separate ordinance, which, by the way, has been in effect in one form or another since 1932. So when this decision, Burko versus Kern, which the Board of Zoning Appeals is required to follow and did follow, this came about in 1993, 94, and I think the appellate division case was in 94. The courts affirmed what the Board of Appeals did, and the Board of Appeals, this town's Board of Appeals, said, yes, it's in single and separate ownership, and it doesn't matter that they were connected in the rear. Now, I talk about this and tell you this because this is a very key issue. And if we look at this property the way we should come to the determination that this property is a back-to-back split. It's commonly known in zoning that back-to-back splits are generally held to be in single and separate ownership, unless, of course, we use the rear vacant parcel for use in conjunction with the dwelling house parcel. So I know you don't have time to look at all of this tonight, but I'd appreciate it if you would take a look at it. The next thing I want to submit to you
More homework?
more homework, is the decision on Burko versus Kern, the decision of the Board of Zoning Appeals, which approves the back-to-back split with maps showing you something somewhat very similar to Mr. and Mrs. Machichi's parcel. Back-to-back split, approved by the courts, approved by our own Board of Zoning Appeals.
The one you're giving us is the one that was used in the current case?
Yes.
Do you have a map of this one?
Yes, I do. It's right in there. On the current case you're talking
No,
about?
do you have a map of the property that we're
Yeah, I do.
talking about here?
I'm coming to it.
Oh, okay.
X.
Exhibit Z?
Do I have what?
Is that Exhibit Z or?
Yeah. Okay.
Is it
I'm
two
coming
pages
to it
here?
right now.
Take a map, yeah, that's it.
I'm going to submit to you as,
Did he get a map?
I don't know if they're
Map?
lettered
Yes.
correctly, but Exhibit F, which shows you the maps of the Machichi parcels. The yellow indicates the house parcel, the green indicates the vacant parcel. In addition, I'm submitting to you the property card, and that property card says that a CO was issued in 1960 for the Machichi dwelling on the separate lot, and that's the yellow lot, the lot that's on Harvard. And the final thing is the tax bills that I was talking about. These are separate tax bills. They go back, I'm showing you a current one, but they go back to at least 1960. And now the health department, as I said, looks at it and says, that's all we want to know. If they were held separately, according to our records from 1980 on, then we can use these for tax credits. And the anomaly of this whole statute that I'm looking at and having to read because of this particular situation is, one, it says you got to go to the Board of Appeal, to the Planning Board, and two, it says, well, you still have to go to the Health Department. The Health Department has to say it's okay too. But the Health Department doesn't even use the same criteria that is named in this, that is promulgated in this statute. Now, I don't think there's any question, no question at all, that if the town board in its wisdom sought to give the planning board the authority to review development rights, the authority to say yay or nay to something that's serious and very important, not only to the fire district, Mr. Zolo's client, but my client, Mr. and Mrs. Machichi, they would have given this whole authority and this whole statute, not to you fellows and lady, they would have given it to the Board of Zoning Appeals and let them decide it because they're smarter than you. I don't know what the whole purpose of this statute is if it wasn't to give you this authority to look at it. Now, the final slap in the face, so to speak, is when Mr. DeRubius takes a position, well, it's not in single and separate. I'm going to go and talk to the building inspector without anybody else knowing about it and asking the building inspector, what do you think? You think you can give me a denial? Sure, he's going to give you a denial because the lot is less than 10,000 square feet, but that's not the issue here. The issue is development rights, and it's completely within your purview to review that, the arguments that I'm making tonight, to decide whether it's in single and separate ownership. You're certainly capable of reading the cases and coming to a decision with the help of Mr. Schul and determine whether it's in single and separate ownership. I can tell you the health department will approve this without a shadow of a doubt because this thing has been, the lots have been in, the tax bills prior to 1980, they've been separate and they've never been combined. They're paying separate tax bills today. I don't know where it says we have to go to the Board of Appeals. It must be in the mind of the planning department. It must be in the mind of Ron Schul. I don't know why. It doesn't say it anywhere, and it doesn't require it anywhere. All of a sudden now we're making new rules. So I disagree with him strenuously, and I think what has to be done here, with all due respect, is this board has to read the ordinance and determine for itself whether it has the authority to hear this or not. I don't want to go to the Board of Appeals. I don't want to waste the time. We have contract restrictions. It's going to put us in a whole nother situation that I don't want to be in. It might get nasty. It's not a good thing. So I ask the board, again, to look at it and come to a decision. They wouldn't have, the town board, and they amended the ordinance besides. The town board wouldn't have given you this authority. Why would they give it to you, the planning board? The question of single and separate has to come up sooner or later in different applications. So now you're sending it over to the other board? No, that's not what the ordinance meant. Now, finally, I have a question. I'm going to direct it to the chairman, and I'm very concerned about it. I heard that there were development rights that the town owns that were offered to the fire district. Now, I hope I'm wrong, and I hope that that's something that was a rumor that was unfounded. But that's what I heard, and I heard it from a couple of good sources, and it was said that the planning department, and specifically Frank, said that we have some development rights hanging around that the town owns, and we can give them to the planning, we can give them to the fire district.
I haven't heard of that, but,
Okay.
you know,
Well,
that's
I mean,
my...
it's easy enough for you to find out. You just can ask the question. And
Yes.
I'm not asking you to do it now, but I think it's something that's got to be answered. If that's the case, and by the way, the contract for the sale of this property to the fire district is part of the file that you have, part of the file that's required by this ordinance, part of the file that John Zolo submitted. So there is a contract there. That contract is a viable contract. Where does the town come off to offer, if it's true, development rights to the fire district? First of all, that in and of itself is an intrusion on our contract. It is an act which, in the law, they call a tortious interference with my contract with my client's contract with the fire district. And that makes me very angry if that's true. My client shouldn't be put in a position to have to bargain against a free development right, even if it isn't free. It has no business being offered at this time when we have a contract. And I ask the board and all the members of the board to check into that. and it's a very, very serious thing. And I don't expect that my clients are going to stand by. It's not my decision, but it's their decision, that if that's the case, that they're not going to do something about it. Don't mean it as a threat, but it's a serious, serious thing. It's an interference, and a tortious interference with my client's ability to sell their property, which is under a contract. And I think that question has got to be answered, and if it's not answered now, it's going to be answered sooner or later, God forbid, in a litigation. So I think it behooves the board to ask those questions, and if I'm wrong, I'll apologize and I take it back, but I don't think I'm wrong. So finally, to sum up, you do have the authority. You can look at the single and separate. You have the authority to make that decision. Excuse me, I just lost my bridge. You have the authority to make that decision, and I think you should.
Mr. Tremarco, I just have a couple of questions. I want to just make sure I have the issues here, if you don't mind. Your client, the Michichis, is in contract with the Smithtown Fire District to sell or to transfer development rights to the fire district.
That's correct.
They own property that adjoins the fire district property?
No, they own property, the Michichis own property which they wish to sell the development rights and keep the property, but it'll be sterilized. They
Right,
could
I'm saying
never build on it.
they're selling the rights to the fire district.
Yes.
Now, in the ordinance that you gave us tonight, we also got a copy from the planning department, talks about 323 section 7. The planning board is authorized, after receiving approval from the Suffolk County Department of Health, to permit a transfer of density flow rights from a sending parcel to a receiving parcel. So the density flow rights is the same as the development rights?
Yes, I've been using the term interchangeable.
So they're interchangeable. Now, you made reference to the ordinance. It's your understanding that in order for the application to be approved by the planning board, someone has to determine whether or not the sending parcel, your client's parcel, is in single and separate ownership, correct?
That's based upon your ordinance, yes.
Okay, so somebody has to
Town
make that
ordinance.
determination.
Yes.
All right. It's your position that we have the authority to make that determination as part of making the determination that the town board authorized us to make concerning the transfer in section 323-7.
That's right.
And it's Mr. Schul's opinion, I think, as he gave to us, that the determination of single and separate is a condition precedent to this determination. It's got to be made by the Zoning Board of Appeals before we can decide this.
Not only that, and I really take exception to the license that Mr. Tremarco has taken, both with reference.
You got to speak louder, Ron. I can't hear.
I take exception to some of your comments regarding, I mean, what you did take great license to bastardize a statute which I read differently. There is nothing in here that speaks about substandard lots. And quite honest, so what you've deferred is that, well, it's not there, but you implicitly read it in because in some way it can be tied to developmental rights. I see that differently. And I offer you this. If you were correct, and we could make a determination, and I find two reasons why your lot is substandard by reviewing the file, and we reach that determination, your lot is substandard, what are you going to do? After, go back and ask BZA for a variance now?
I'm going to sue you. That's what I'm going to do.
Well, you're not going to ask
sue
for
the board.
You,
If they find that
well, I'm
it's
glad
not
you
in
clarified
single
that.
and
Let
separate
me
ownership.
finish. I didn't interrupt you.
You asked me what I was going to do.
I asked
told
you, would you go back to ZBA and request a variance
And I
then?
said no. I would sue the planning board because they made a decision which I think is incorrect pursuant to the statute.
Okay.
Now, this statute, in answer to your other question, this statute, this ordinance, we should say, doesn't say anything about going to the Board of Zoning Appeals. It's a figment of everybody's imagination. Why should we go there?
Doesn't it, because it takes as a given that the lots we would consider are standard.
Does not.
You see it differently. You have great minds can disagree. The fact of the matter is, you can't take the license you have and tell this board it's assumed that we have that right, because I can give you reasons why it's not. For instance, on talking about, you said this lot qualifies in all regards. On subdivision 32310C, It says, "Property improved with buildings or other improvements, unless a distinct open space parcel can be defined therefrom, and the severance of that parcel would not create a substandard lot." Is there a house on the property, a building on a property?
No,
There's no building on either one of these properties.
that's not the question. You said, is there a building on the property? Which property?
Well, the parcel you're calling is one. The parcel you're
There's a
defining
dwelling as... house parcel.
If
which
you took
they-
out that building, is a lot, do you have 10,000 square feet?
On which, the parcel that...
If you
the-
took out the
No,
building...
you have 8,000 square feet, which was CO'd by the town in 1960.
What do you do variance for that then? 8,000? With an 8,000 square foot parcel, it's substandard, is it not?
It's not because
I thought
it
the
was
minimum is
CO'd.
$10,000, there's 10,000 square feet in this town.
You know what, you just, I guess you don't get it, Ron.
I guess I don't.
There's a building department card. The town CO'd this parcel, this house, on an 8,000 square foot parcel. It
That's-
CO'd it. You got it in evidence
That's not
there.
what this says. We're not talking about the C of O. It
Well, that's
says
what I'm talking about. It doesn't matter. That's
Rule-
a CO'd piece.
Rules
Put
for
it aside.
rules for transfer of density flow rights, standards. Under the standard C, I read again, property improved with a buildings, or other improvements, unless a distinct open space parcel can be defined therefrom, and the severance of that parcel would not create a substandard lot. If you take the dimensions of the house, you subtract it from the total lot you're calling one, single and separate, would you be 10,000 square feet or not?
You would. However,
Well, then you
the
qualify.
property was CO'd in 1960, and it doesn't, you take that out of the mix.
I guess.
You're saying it wouldn't be substandard because the town CO'd it in 1960?
That's right, that's right. I could sell that property to a guy that wants to farm, and the town couldn't come to me and say, well, now you gotta get, 2,000 square feet to make it 10,000. I'd say, what are you talking about? I got a CO on an 80 by 100 since 1980. When Machichi built the house, he didn't even own that plot on Osgood. So now what are they saying? Okay, now you got to add that plot to that. It's just fooling around with words.
What it is cumbersome. That we can agree upon. And that's the very reason why I suggest the methodology I suggested is the appropriate one.
If it's
Because
cumbersome, then that should be,
we deal with subdivisions.
it should be,
and
wait a
not
minute,
variance.
if it's cumbersome, then that should be militate against the board, not against my client. It shouldn't be a situation where now I have to figure out where to go because the
Mr.
town didn't do an ordinance that
Mr.
made any sense.
Mr.
And I don't think
Tramarko,
it's cumbersome.
your
I think
contract
it's
was
clear.
signed September 13, 2010. If one of you, either you or Mr. Zola, had acted expeditiously, you're both experienced in the area, and made an application in October of 2010, rather than March 31st, 2011, we wouldn't be running through this circus right now. And you'd be in a proper forum, whether
I'm
it be
glad
here
you
or
said
ZBA.
that. I'm glad you said that, because it was this board, planning department's holdup, and you can ask Mr. Zolo, because if it wasn't, then Mr. Zolo's got a problem. He put in right away, he made his application, and then you know what
March
happened? They
31st.
said, wait a minute, let's wait a while, because we're going to amend the ordinance that's going before the planning board. And he got suckered in. And John, if you want to answer that, go ahead.
Well, I'm informed by the planning director that the plot didn't qualify at that time. But in any event, the filing was made March 31st of 2011, and that's why we're on a short window right now. And in fact, the solution I made to you, whether the forum be here or ZBA, the resolution was an appropriate one, because the ZBA deals with them regularly, we both acknowledge that fact. And the fact is, if you went before the ZBA, you'd be just as successful if your property qualifies as you would here. In any event, I've said enough.
John, you want to answer that?
Members of the board, as you know, I wasn't given the courtesy of knowing I was going to be presenting anything tonight. I prepared an outline and a presentation of why I think this board has the authority to hear this case. But I first want to just make a point to Mr. Schul. I went, when this transaction first occurred, I went, before we signed contracts, I went to the planning department and said, we're thinking of purchasing this piece of property. I met with Allison and Dave Flynn from the planning department. They said, yes, this is in the zone that we want, and this would work. Okay, what are we doing? We have the new TDR ordinance. I'm going to prepare the papers to submit it. Then I was informed that they're making changes because the ordinance as it was presently constituted at that time would not allow for this piece of property because it's a 6,000 some odd square foot parcel, would not give the yield of 196 gallons per day that we needed. And Dave Flynn had suggested, hold off, we're going to be making an amendment to the ordinance. I held off to wait for the ordinance to be amended. It delayed the application process. Also, there was no survey for the property, and we had to survey the property. And because of the winter that we had, it was tough getting a surveyor out there. But I take offense to the delay issue because I was relying on representations and working with the planning department. Recognized this was the first time this application of this sort had ever come to the planning board. Everybody was in a learning curve. So I was specifically asked to hold up. I went to Mr. Flynn and said, I'll submit an application now. He said, what's the point? It's going to sit until we figure out what we're doing with the ordinance. I'm not knocking Mr. Flynn or Alice or anyone else from the planning, I'm not knocking anyone from the planning department, but I don't want to have something cast on, aspersions cast on me because of the process that was in creation. And it's troubling when that happens. I worked with the planning department for many years, both as the attorney for applicants and with them as town attorney. And I respect them, and I take their word when we go forward on things, and I listen to them when they make suggestions. And that's what I did here. And I'm bothered by that. It's upsetting to me that you would, I guess, cast those aspersions because that's what it's coming across at to me, and it's troubling. But what also is troubling, I submitted the application on March 31st. I wrote letters to the planning department. I wrote letters to the planning department, please let me know when you're going to be submitting the zoning ordinance amendment because my client wants to get the application filed. I documented my file with letters because of the time delays. I was concerned about that. It's also troubling that when I filed the application, I called up to find out when I was going to get a hearing date before the planning board, and I was told by Allison in the planning department, well, you're not getting a hearing because we're waiting for you to submit us your submission for the board. Because Dave Flynn had said, we're taking the application as the issue of single and separate. Be prepared to argue that point to the Board of Zoning Appeals, which I was, which I have cases similar to some of the cases that Mr. Tramarco cited to you. I have those cases. I was prepared to make a presentation to this board because no one ever said the board had no authority to hear these TDR matters and single separate issues because I believe Mr. Tramarco said that this ordinance was designed to give you the authority. We're not building a building, we're sterilizing property. Also, in relying upon that, I have meetings with the fire district. I called up to try to find out when I was going to get my hearing. It was not until, I believe, April 28th or so when I was told that it's not going to the planning board. You have to go to the Board of Zoning Appeals. And that's troubling because, first of all, I don't think Chapter 323 requires that. And then for the department not to know how the ordinance is proceeding and to make a last-minute call is embarrassing to me. It puts me in a difficult position. And as a courtesy to Mr. Tramarco, who I respect tremendously, I called him up and said, here's the problem. And that's what ensued. I represent the fire district who wants to build a firehouse on Plymouth and Asbury who needs transfer development rights because the building has a second floor, the square footage is too big. It's going to have 3 bathrooms in it. The whole process is absurd. And to have my fire district involved in this process, which is becoming a battle now between Mr. Tramarco's client and the planning board and the Board of Zoning Appeals, is not what I wanted. My fire department wants to build a firehouse. That's what they want. It's a public service. It's for the community. And we're caught in this process, which is becoming more complicated, and it's really a shame because it was better left with the county. It shouldn't be before you, as Mr. Tramarco said, and I was prepared to go through this tonight. But as Mr. Schul made an opinion that this board had no authority, I was laying back. But these 2 lots, the lot that has the house on it, which was CO'd in 1960, and the lot that fronts on Osgood, were all separate tax lots going back prior to 1980. Mr. Machichi bought this lot number 68, in 1967. He put it into a Machichi Living Trust in 1997. He bought the house on Harvard, which is tax lot 51.1, I believe, which is on the south of the current lot. They have frontage, separate frontage. As Mr. Tramarko said, they're back-to-back splits. It's not that complicated. But here we are. Mr. Tramarko's in a heated debate with Mr. Shul. My client just wants to build a firehouse. It's for the public good, and we're going to get caught in this, and it looks like litigation is going to be coming down, and that's not what the purpose of the ordinance was for. So if I could just give you a brief history of the fire district, since you've had my ear, and I want to outline to you what this is all about, maybe I can convince you that you do have the authority, and we don't have to go to the Board of Zoning Appeals.
Okay.
Well, it seems at some point, someone has to make the determination as to the single and separate issue. And you're saying that we can do it. Mr. Shul says that really the Zoning Board of Appeals has to do it first. And we have an ordinance here that people are all talking about. We may need an opinion from someone as to what they intended when they passed this ordinance, as to whether they intended to have the planning board address a single and separate issue, or whether or not that was intended to remain with the Zoning Board of Appeals.
Mr. Earhart?
Well, I think, the memo that Mr. Tramarko submitted from where was it? Let me find it. From
Do you have any other
Dave
stuff
Flint
that
to.
you want to give us, Mr. Zolo?
Yes.
Yeah. It's true. It's that memo lays out a cogent method of approaching it. Now, that's not codified anywhere, and I spoke with the town attorney about that. Obviously, the procedure should have been important.
Has this board, the planning board, ever made a determination? Ever?
Even the case Mr. Tramarko gave you from the ZBA.
All the cases are from the ZBA.
Yeah.
So I guess the question is when they passed this ordinance, did they intend to override what the practice had been before and let this board address that issue?
Everything that I might suggest is pure conjecture, because they were looking to draft a statute that with development rights. I don't think the possibility of a substandard lot was ever considered in the drafting of that.
But that's exactly right.
Yeah.
And I gave you a packet, and I want to go through this, and I appreciate the board's patience with me here. But that's exactly right. If you look at Chapter 323, it specifically states, 323 Sections 7, A, B, and C, that the board has the authority to determine the number of density flow rights pursuant to Chapter 323, 7, A, B, and C. That's what you're doing. This is not a buildable parcel. There's no structure going on. It's density flow rights. That's what's before you. What I gave you,
I just have a quick question about this. Looks like we've been given a letter dated March 10th, 2011, addressed to the planning board. I don't recall ever seeing this letter before.
that's a letter of intent that was submitted with the application, which you probably haven't seen yet, because the determination was that it wasn't coming to the planning board.
My issue is not with you, but there's a letter here addressed to us, March 10th, 2011, that I've never seen before.
That was submitted with the application.
Understood. But why haven't we seen this letter if it's in March of 11, addressed to us?
Right. Mr. Zoll, let me ask you a question, if I may. When were you made aware of that there was an issue as far as what we're just touching on this evening, as to the process of single and separate? Was it a recent discovery by your office, or were you told initially when you made the application?
Oh, see, that's the problem. You know, we could be here a long time because,
Well,
but the answer to the question is, when I got the application, after was arranged, after the ordinance was passed, I got the application. And in the packet I gave you is the blank application. And I'll ask you to take a look at it because you'll see my problem. If you look at the first page of the application, materials to be submitted with application for a letter of interpretation. That's what we're here for. It tells you the 2 completed letters of interpretation, 2 copies of current property survey, 2 copies of the description, copy of all deed and all covenants, copy of most recent tax bill, 5 copies of a yield plan, but it's a single lot, so we gave the survey, and a processing fee of $500. That's the application, that's your instruction sheet. We do the application, you go to the next page. Oh, and by the way, as you look at that first page, nothing says anything about a letter of intent. That's not on there. You go to the page of the application, and question number 8 says, is lot held in single and separate ownership from all adjoining parcels? Initially, I checked the box yes, because I think it is. But then I had looked at the chain of title, which you have. I gave you the 2 pertinent portions for each lot.
Right.
And I said, well, there's a portion of 5.1 which touches the southerly portion of 68. I was troubled by that, and I went to planning. And I spoke to Mr. Flynn, and he said, yeah, it's a problem. You might want to, and what I suggest is getting an affidavit from Mr. Chichi just so you can outline that that parcel 68 was never used to benefit the parcel that fronts on Harvard. And the conversation was Osgood and Harvard, they front on separate streets that historically these lots are fine, but submit that when you submit your application. So I get Mr. Machichi's affidavit. So right now on the application process, I have a letter of intent, which doesn't ask for it on the application. I have the affidavit, and we're not sure about single and separate ownership. But I was assured that this would go to the planning board, and that's why I submitted the application. And I was told, when you go to the planning board, be prepared to present why you think this lot will be acceptable for the transfer of development rights, including case law or anything else that you think would be necessary. And that's what I did.
Who told you that?
Mr. Flynn. Oh. And everything was in order. I never got a hearing date, and that prompted me to call the planning department. And I actually wrote a letter, I think 1 or 2 letters saying I've submitted the application. I haven't heard about a planning board date yet. Could someone please get back to me? And when I called up to find out, because I had a meeting with the fire district to update them on the application, I wanted to apprise them of when I expected the hearing was going to occur. And that's when I was told that day, and I forget the date, I think it was April 28th, I'm not sure. It was a Monday, that you're going to have to go to the Board of Zoning Appeals to get an interpretation as to the single and separate status of the lot. And that's what has engendered all of these gymnastics, if you will. So the letter of intent was prepared, outlines what the application is, and you have that, so that's part of the record. Just a brief overview of the part.
But when did you make application? When was the initial application made?
March 31st,
Of what year?
2011.
But you were in contract prior to that?
Yes.
Excuse me, Mr. Zolo. Can I get an answer to my question about why we weren't provided this correspondence, please? From planning?
I'm sorry, what was the question?
We have a letter here addressed, Dear Members of the Planning Board, by Mr. Zolo, dated March 10th, 2011. I do not recall ever being provided with this letter before just now by Mr. Zolo. Why weren't we provided with
Well,
the
first off, I don't have a record of that letter in our file. I brought the file with me. There is no record of the letter. It could possibly be that it was misfiled or a letter was received, but, and I'm not doubting John usually is fairly thorough, but I don't have that letter in my file. And that's a letter of intent, and what that does is if we did have it and it's necessary for this particular application, the reason why the planning board would not receive it if that's a letter of intent is that when the public hearing is held for the transfer of development rights, all the documents are given to the board. It's not, we don't give you correspondence as we receive it.
But this was mailed to you, though?
No.
Was it mailed to planning?
Hand delivered.
hand delivered.
I have my cover letter, which via hand delivery, March 31st, 2011.
Mr. Zolo, if it was delivered March 11th, the
No,
application,
March 31st.
no, the application was received March 31st. If there was if this was with the application, it should be in the file. If it was hand-delivered afterwards, then
No.
all I could say is that it's probably is either misfiled or in another application. But that is not the issue that is before us right now.
No, and it was hand delivered with the application, but I wanted to give you a brief background on the application, if the board wants to hear that. The Smithtown Fire District's application was filed on March 31st, 2011, in order to receive a letter of interpretation from the planning board. I provided the March 10, 2011 letter of intent with that. The subject parcel that the district wishes to purchase was obtained by Peter Machichi and Dorothy Machichi in 1967. It has maintained a separate tax lot number. The deed was filed separately. Peter and Dorothy Machichi had owned an adjoining parcel bearing tax lot number 51.1 since 1958. In 1997, Peter and Dorothy Machichi transferred both tax lots into the Machichi Living Trust for estate purposes only. Both parcels still receive separate tax bills and were filed as separate deeds under separate Library page. Since 1967, Dorothy and Peter have owned both parcels by two different deeds. They never merged the lots by a common deed into the trust. That should be good enough for the planning board to make a decision on this application. The purpose of the statute is to allow the planning board to make determinations with respect to transfer of development rights, and there should not be any objection to granting the relief on this property. As Mr. Tramarko's indicated, the parcel on Harvard, where the house is, has a CO since 1960 on an 8,000 square foot lot. This property fronts on Osgood Place, has a separate tax bill, has always had a separate tax bill, and as Mr. Tramarko indicated, merely for estate planning purposes was put into the trust. But the parcel has always maintained an independent and separate identity, and purposes of this application, the health department recognized it as being a separate tax lot since prior to 1980. I'm asking this board to look favorably on the application and recognize that under Chapter 323, you have the authority to make a determination and grant the transfer of development rights for this property.
Mr. Zoll, this may be a dumb question, but maybe you can clarify. I think everybody agrees that in order for the transfer of the development rights to be approved, has to be determined that the sending parcel is in single and separate ownership as opposed to all the adjoining parcels, correct?
Correct.
Why is that? Why do you need that single and separate determination?
Well, in order to get the yield from that property, for 300 gallons per day in that district is what that property would yield. The fire district needs 196.1 gallons per day for the property. If you were to take a percentage of if that lot is not deemed to have a full, and how to describe it, the full yield of 300 gallons per day, if you take it a percentage, then it would not suit our purposes. It wouldn't have enough yield if it were to get health department approval. My contention is that if this board did not, if Chapter 323 hadn't been adopted and we went to the health department on this parcel, because it has a separate tax lot, it's existed since prior to 1980, we would get health department approval on this and they would get the TDRs. But now, because of the Chapter 323 and the opinion that this has to go to the Board of Zoning Appeals, it complicates the process terribly and prolongs the process. Did I answer your question?
I don't think so.
Okay. Run me by
In
it
other
one
words,
more time.
why does it have to be declared single and separate in order for the transfer of development rights to be approved?
I don't think it does. I think we can get the yield because I believe the parcel is a separate parcel.
Well, the question is, somebody has to determine whether the sending parcel is a separate parcel from what appears to be an adjoining parcel that was at some point owned by the same people, right? That's what you need to have determined by somebody?
Right.
My question is, why do you have to have that determination in order
Because
for the rights to go through?
If it's not single and separate, it's merged, and then there's no yield from that property, and it becomes a piece of property that you can't do anything with.
Maybe a question for Mr. Tramarko is, when do these properties, we're going to say, become merged? Knowing that they were single, that we have two different tax bills, we have two different frontages. When did they become merged? Well, was it by the mere fact of the same owners, or was it the fact of the trust?
Well, the trust is what put them in the same ownership.
So the trust is what, aside, if we could just go back for a moment, and again, this is all opinion, if we take out the concept of the trust, or the fact that there is a trust, knowing that one property's frontage is Harvard and one property's frontage is Osgood, would these be considered, in your opinion, or Ron, in your opinions, as single and separate?
Well, obviously, in my opinion, they're in single and separate, even though they're in the trust.
But we're going to just go back, because I think what we're saying is the trust is what made them marry together, merged, as technically what we're saying as an opinion, that they're no longer considered single and separate.
That's I guess, Ron Schul's opinion.
But
The cases that, let me just finish, the cases that you have talk about back-to-back splits. And it could be in Vincent Tramarko and Vincent Tramarko, but the two properties back up to each other, like you see in the map that I
But they
gave
have
you.
separate, but they have technically different, or as it appears, that they have different frontages.
That's correct. And they have a common, very important,
A common rear yard.
rear boundary line, which was never intended
To be
unless
merged.
by user, that they would be one parcel. In fact, all the parcels along the road there, they're not, they don't extend into Osgood Place wherever there's an opportunity to do it.
It isn't as if they were adjoining lots going
Adjacent lots, right.
Adjacent lots.
Right, exactly. Because if they were adjacent lots, we'd have a different issue.
We'd have a different issue.
And we'd have a problem because they're considered merged. I've handled cases where we've gone to the appellate division, a person dies, leaves property to his son owns the adjacent property, didn't do anything wrong but died. They're considered merged and you're done. But that's adjacent. It's not back to back. That's why I handed you the cases that I did, and our own Board of Zoning Appeals recognized that in 1993. And the final thing, oh, go ahead, I'm sorry.
So it was the trust that merged these two.
Well, I mean, technically they're in the same name. Obviously, we can't argue that they're not.
We
They are.
can't take that away, but Frank, are we saying it was the trust that merged these prior to the trust?
Well, we're not. I think before we even get to this, I think
But
we need
I
some
think,
type
I
of
think
an
there
opinion
needs to be
as to whether or not
an
we can.
investigation done of the material that's been given to us. And then we can get Mr.
Fine.
Schuler can give us an opinion there that we can deal with.
They need a break in the tape, Mr. Chairman. They need a break.
Okay. All right, take a minute.